The Senate is back in order. We are on order of business 13, general file. Senator Cannizzaro.
Thank you, Mr. President. I would move to take the following Senate bills from their place on general file and place them at the top of general file. Senate Bills 198, 218, 251, 258, 268, 278, 284, 285, 294, 295, 305, 306, 313, 319, 326, 330, 334, 338, 340, 346, 347, 379, 404, and 408.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I would also move to take Senate Bill 341 from its place on general file and place it on the Secretary's desk for purposes of further discussion.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries.
Senate Bill 198, introduced by Senator Daley, revises provisions relating to labor. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 7, end of Section 7, end of bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 198 makes various changes to the payment of wages and compensation of an employee who resigns, quits, or is discharged, or is placed on non-working status, including requiring an employer to pay compensation earned and unpaid at the time of discharge, resignation, or quitting in the same manner and on the same day on which the employee would have regularly been paid, and revising the amount and circumstances of the penalty imposed upon the employer who fails to comply with certain requirements concerning the payment of wages and compensations. What I just read is not exactly correct, but nevertheless, a couple of comments if I can. Currently, the way the law exists now, wages and compensation are due immediately. A penalty kicks in if you don't pay within 72 hours. The bill, if it goes through, will change the compensation and may give a new definition. That portion, compensation, would not be due immediately. It would be due at the regular time that it would have normally been paid. If this bill doesn't pass, wages and compensation, regardless of whether people think it works that way, wages and compensation would be due immediately, and there would be a penalty after 3 days. So I would urge everyone to support it. It would be beneficial to all sides. It does increase the penalty if you're late, if you violated the law, but addressing that compensation issue is going to put everybody doing it different than they think they have to do it now. So just want to make sure people understand that.
Any remarks on the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 13 and noes are 8. SB 198 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 218, introduced by Senator Orenshaw, enacts the Uniform Antitrust Pre-Merger Notification Act. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 20, end of Section 20, end of bill.
Senator Orenshaw.
Thank you very much, Mr. President. Senate Bill 218 enacts the Uniform Antitrust Pre-Merger Notification Act, which generally requires certain persons who must file a notification under the federal Hart-Scott-Rodino Act to file that same notification with our state office of the Attorney General contemporaneously with the federal filing. Such filings are confidential with certain exceptions for investigatory and law enforcement purposes. Senate Bill 218 requires a court to consider the promotion of uniformity of the law among jurisdictions that enact the Uniform Act and applying and construing the provisions of the Act. I believe that, Mr. President, this bill will help protect our constituents from anti-competitive mergers, and it does not require the State Attorney General to take any action, but it would provide them that same notice that their counterparts at the federal level, at the Federal Trade Commission, the Antitrust Division of the Justice Department already get. I urge its passage.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 13, the noes are 8. SB 218 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 251, introduced by Senators Scheibel, et cetera, revises provisions relating to psychological assistants, psychological interns, and psychological trainees. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 29 into Section 29 into bill.
Senator Scheibel.
Thank you, Mr. President. Senate Bill 251 provides the Board of Psychological Examiners to issue provisional licenses to psychological assistants and psychological interns who can meet certain conditions, and revises provisions governing the registration of psychological trainees.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 251 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 258, introduced by Senators Wynn, et cetera, revises provisions relating to industrial insurance. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3 into bill.
Senator Wynn.
Thank you, Mr. President. That came up so much faster than I thought. Senate Bill 258 provides that the maximum amount that an industrial insurer or an administrator of the uninsured employer's claim account or a subsequent injury account may recover for a lien against the total proceeds of any recovery by an injured employee or the dependents of the employee must be the lesser of 1, the full amount of the lien, or 2, 1/3 of the total amount of any recovery, inclusive of any attorney's fees or costs. Additionally, except where the full amount of any lien may be recovered, this bill requires the lien amount be reduced by the amount equal to 1/2 of the reasonable expenses incurred by the injured employee or the employee's dependents in procuring the recovery, which must be verified by a certified public accountant and is subject to judicial review under certain circumstances. This bill also limits any offset to the amount of future compensation received by the injured employee or the employee's dependents to 1, an offset against compensation payments that are not accidental benefits, and 2, a reduction in each of such payments which does not exceed 1/3 of the amount of the payment until the total amount of such reductions equals the total amount recovered less any applicable reductions. This bill is effective upon passage and approval. To put this plainly, this used to be the law for about 40 years, and then the Supreme Court of the state of Nevada said this is something the legislature should do. So this is what this bill does, is we are doing what the legislature should do, and we are codifying what has been in practice for about 40 years.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SB 258 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 268, introduced by Senator Flores, revises provisions relating to insurance coverage for certain dental services. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 17 into Section 17, end of bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 268 requires certain public and private health insurance policies and health plans, including Medicaid, to cover various dental services provided by a qualified dental hygienist while not supervised by a dentist to the same extent as provided under a dentist's supervision. The Department of Health and Human Services must apply for any necessary waiver to federal law or amendment to the state plan for Medicaid to receive federal funding to carry out the provisions of the bill.
Any remarks from the floor? Seeing none, the secretary will open the roll. Senator Ellison. It's time to vote. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 268 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 278, introduced by Senators Cruz Crawford, Orange Hall, Deñate Flores, Wynn, and Assembly Members Gonzalez and Torres Fawcett, revises provisions relating to education. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 3.5 into Section 3.5 into bill.
Senator Cruz Crawford.
Thank you, Mr. President. Senate Bill 278 relates to pupil deficiency in reading and access to licensure. It requires the Commission of Professional Standards and Education to consider and adopt regulations improving access to the licensure and endorsement of educational personnel. 278 provides that pupils who no longer are deficient in reading based on statewide assessment results are not required to continue receiving related services for instruction. This bill becomes effective October 1st, 2025.
Any further remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SB 278 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 284, introduced by Senators Canizaro, et cetera, revises provisions relating to child welfare. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 7 into Section 7 into bill.
Senator Canizaro.
Thank you, Mr. President. I rise in support of Senate Bill 284. Senate Bill 284 requires any agency that provides child welfare services to determine if each child in its custody is receiving or eligible to receive federal benefits within 60 days of custody and annually thereafter, and apply promptly for federal benefits on behalf of the child if the agency determines a child is eligible but is not currently receiving benefits. If the agency applies for those benefits, it must determine whether there's a person who may be a representative payee for receiving them, and if not, it must apply to be such a payee. If an agency is approved to be the representative payee, it must establish an account for the child in order to use and conserve the federal benefits instead of depositing the funds in the trust fund for child welfare or a county-operated trust fund for child welfare. Such money may not be used for the cost of the child's care, and certain accounting is required. And further, the agency must discuss related matters with the child and the child's attorney and provide certain financial counseling to a child who is 14 years old or older. This basically allows for children who are in our foster care system who are receiving federal benefits from Social Security disability or from death benefits to have that money deposited into an account that they may use. That's money that they are entitled to and currently is not being utilized in that fashion. And so I would urge this body's strong support to help set up those foster kids for just a little bit more in life by allowing them to access the money that they are owed. Thank you, Mr. President.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 14, the noes are 7. SB 284 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 285, introduced by Senator Daley, revises provisions relating to apprenticeships. People of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3 into bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 285 requires a proposed apprenticeship program that provides training in more than one specified construction trade to contain separate standards for each such trade in order to be eligible for registration and approval by the State Apprenticeship Council. If a set of standards that does not comply with the provisions of this bill has been approved for a program before October 1st, 2025, the program may continue to use that set of standards until it is voided or superseded.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 16, the noes are 5. SB 285 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 294, introduced by Senator Flores and Assemblymember De Silva, revises provisions relating to physician assistants to people of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3 and a bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 294 requires the Board of Medical Examiners and the State Board of Osteopathic Medicine to authorize a supervising physician or osteopathic physician to simultaneously supervise not less than 6 physician assistants. Colleagues, I do know that the amendment reads a bit odd. We will continue to work on it to ensure that we're making it abundantly clear that we will have 1 physician supervising up to 6 physician assistants, and that is the intent of the bill, and we will continue to work on it on the other side to make that clear that that is our point. I urge your support so that we can continue working on the amendment.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 15. The noes are 6. SB 294 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 295, introduced by Senators Duñate and Flores and Assembly Members Gonzalez, Moore, and De Silva, revises provisions relating to food establishments, to people of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 16 into Section 16, end of bill.
Senator Donate.
Thank you, Mr. President. Senate Bill 295 revises provisions relating to sidewalk vendors, defining terms and requiring certain local boards of health and certain local zoning boards and planning commissions and local governments to adopt certain regulations. In addition, the bill exempts certain establishments from existing food establishment requirements. Among other provisions, this bill requires local boards of health to develop guidance documents for sidewalk vendors and makes them available in multiple languages. Mr. President, I just want to make a quick remark that this bill is as a result of conversations that we've had over the last 2 years. This is the amendment that was adopted is a compromise amendment, and I hope that this is our way to protect public health, but also streamline our licensing requirements for many of these vendors. So I urge my colleagues to support this bill.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 17, the noes are 4. SB 295 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 305, introduced by Senators Duñate, et cetera, revises provisions relating to interscholastic activities, the people of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 7 into Section 7, end of bill.
Senator Taylor.
May I have a 1-minute recess, please?
Sorry,
1-minute recess, please.
we are in recess. So that's SB 305. The Senate is back in order. We are on order of business 13, general file. Senator Cannizzaro.
Thank you, Mr. President. Can we please take Senate Bill 305 from its place on general file and place it on the Secretary's desk for the purposes of amendment?
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries.
Senate Bill 306, introduced by Senator Cruz Crawford and Assemblymember Moscow, revises provisions relating to mental health services for children. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 4 into Section 4. End of bill.
Senator Cruz Crawford.
Thank you, Mr. President. Senate Bill 306 requires the Administrator of the Division of Child and Family Services to accept and provide services to a child who is subject to certain court orders. If the order requires the child to be committed to a treatment facility, the Administrator must place the child in a facility within 30 days under certain circumstances. This bill also requires the public and private inpatient psychiatric facility that admits a child with an emotional disturbance to establish discharge procedures that require the court approval of discharge plan for a child's parents or legal guardians do not approve, prohibit discharge for temporary facility, and require approval by child welfare agency receiving the child after discharge. This bill becomes effective October 1st, 2025.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 21 and noes are 0. SB 306 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 313, introduced by Senator Daley, revises provisions relating to state purchasing. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3. End of bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 313 requires the Administrator of the Purchasing Division of the Department of Administration to take certain actions before entering into a contract for services without competitive selection. The Administrator must submit an annual report to the Interim Finance Committee, the Audit Division of the Legislative Council Bureau, and in even-numbered years, the Audit Subcommittee to the Legislative Commission regarding such contracts. The bill also authorizes the Administrator to extend the contract for services and provisions and provides a procedure for the extension of such a contract. Lastly, the bill requires the Administrator to submit a report to the Legislative Commission regarding any using agency that fails to comply with the procedure and requires the executive head of such using agency to appear before the Legislative Commission to explain the noncompliance.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 21 and noes are 0. SB 313 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 319, introduced by Senators Daley and Taylor, establishes provisions relating to county fire protection districts. The people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
I have amendment number 547, proposed by Senator Daley.
Senator Daley.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Daley.
Thank you, Mr. President. I move to adopt Amendment 547 to Senate Bill 319.
You've heard the motion. Senator Daley.
Thank you, Mr. President. Essentially, what the amendment does is remove all of the enabling provisions. The only thing that's going to be left is a mandatory study by the three entities, Washoe County, Reno, and Sparks, to determine if consolidating the fire departments is in the interest of the three entities, and report back with recommendations.
Any further remarks on the amendment? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 319 is now ready for final consideration.
Senate Bill 319, introduced by Senators Daley and Taylor, as amended, requires the Washoe County Board of County Commissioners, Reno City Council, and Sparks City Council to establish a board to study the creation of a county fire protection district within certain territory. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1, end of Section 1.
Are there any further amendments?
There are none. Section 18, end of Section 18, end of bill.
Senator Daley.
Thank you, Mr. President. As we just heard, it's now the study only with further recommendation from the three government entities in Washoe County.
Any comments from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Secretary will close the roll. Yeses are 16 and noes are 5. SB 319 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 326, introduced by Senator Cruz Crawford, requires certain public utilities to submit an annual report to the Public Utilities Commission of Nevada relating to the infrastructure of the public utility. People of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1, end of Section 1.
Are there any amendments?
There are none. End of bill.
Senator Cruz Crawford.
Thank you, Mr. President. I rise in strong support of Senate Bill 326, which will close a reporting loophole that has allowed certain small regulated water utilities to avoid reporting on adequacy of their infrastructure, including adequacy to provide water for fire protection to their customers. To be clear, Senate Bill 326 applies only to small service providers that serve 3,000 or fewer customers in Clark County. But those customers deserve the same level of assurance that their regulated water utility has adequate infrastructure and service capacity. This bill will help provide that assurance, including schools, small businesses, and other customers. I urge your support for this measure. Thank you. This bill becomes effective October 1st, 2025.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 21, the noes are 0. SB 326 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 330, introduced by Senator Neal, revises provisions relating to facilities for skilled nursing. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, end of Section 5, end of bill.
Senator Neal.
Thank you, Mr. President. Senate Bill 330 amends the definition of facility or skilled nursing to clarify the facilities or skilled nursing to provide inpatient care. Basically, if there's a city or county ordinance, it must align with the current NRS statute.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 14, the noes are 7. SB 330 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 334, introduced by Senator Neal, revises provisions relating to the employment of offenders. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, end of Section 5, end of bill.
Senator Neal.
Thank you, Mr. President. Senate Bill 334 requires the Director of the Department of Corrections to submit a report on or before March 1st of each year to LCB stating the number of offenders who were eligible for employment, employed, or refused employment, the pay of the offenders who were employed, the amount of the deductions from the accounts of the offenders who were employed, and the percentage of offenders who found employment following release within the industries in which they were employed inside of the prison. It's effective October 1st, 2025.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 14, the noes are 7. SB 334 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 338, introduced by Senators Pizzina, et cetera, revises provisions relating to the sale of tickets to a live entertainment event. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 12 into Section 12, end of bill.
Senator Pizzina.
Thank you, Mr. President. Senate Bill 338 prohibits a live event ticket provider from offering, displaying, or advertising any ticket price without clearly, conspicuously, and prominently disclosing the total price of the ticket, with certain exceptions, and from misrepresenting any fee or charge. A ticket provider must disclose certain information through various means to a consumer before the purchase of a ticket and refund within 30 days the full ticket amount, including all applicable fees and governmental charges, in case of a cancellation of the event to which the ticket pertains, with certain exceptions. The Bureau of Consumer Protection must accept reports of violations of these provisions, and the bill deems a willful and knowing violation a deceptive trade practice and makes such a violation punishable by certain criminal penalties, but an individual may not bring certain civil actions against a ticket provider. So all-in pricing as well as ticket refundability except for force majeure.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SB 338 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 340, introduced by Senator Daley, revises provisions relating to governmental administration. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 18 into Section 18, end of bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 340 establishes a process by which a person or adopting agency may petition the Legislative Commission to review a regulation to determine whether it should be suspended or nullified. The grounds to petition such a review must include one or more of the following: the regulation exceeds statutory authority, conflicts with its legislative intent, or is not being administered or interpreted by the adopting agency in a manner consistent with the agency's stated intent during the adoption approval process. The bill outlines procedures for reviewing such petitions, including opportunities for public comment, and specifies that decisions by the Legislative Commission regarding suspension or nullification of regulations are final and not subject to judicial review. Lastly, the bill directs courts to give significant deference to the Legislative Commission's determinations regarding the validity of regulations when those determinations are challenged in legal proceedings. Finally, the bill requires the Legislative Commission to adopt such regulations or as necessary to carry out the provisions of the Nevada Administrative Procedure Act governing administrative regulations.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 13, the noes are 8. SB 340 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 346, introduced by Senators Scheibel, et cetera, makes various changes relating to guardianship. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 7 into Section 7, end of bill.
Senator Scheibel.
Thank you, Mr. President. SB 346 is a bill to ensure that individuals in Nevada who might otherwise be subject to guardianship are first afforded the opportunity to participate in a less restrictive alternative, specifically in either supportive decision-making or in a power of attorney. And so SB 346, as amended, ensures that a court in any case where a person is not able to live completely independently is first provided with the opportunity to participate in supported decision-making before moving on to considering power of attorney, before finally possibly putting them under a guardianship. SB 346 also includes provisions for individuals who are traveling to Nevada or moving to Nevada from another state to ensure that they receive the same protection, same consideration, and have that opportunity for additional independence as they become young adults and become adults. And I urge my colleagues' support.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, and noes are 0. SB 346 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 347, introduced by Senators Scheibel, et cetera, revises provisions relating to mental health crisis holds to people of the state of Nevada represented in Senate Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 539, proposed by Senator Scheibel.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 539.
If there are no objections, so ordered. Senator Scheibel.
Thank you, Mr. President. I move to adopt Amendment 539 to Senate Bill 347.
You've heard the motion. Senator Scheibel.
Thank you. Amendment 539 aligns the return of a firearm with the existing process outlined in NRS 33.560 and provides that a firearm must be in the custody, control, or immediate vicinity of the person.
Any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. The bill is now ready for final consideration.
Senate Bill 347, introduced by Senators Scheibel, Canizaro, Dondero, Loop, and Pizzina. As amended, revises provisions relating to mental health crisis holds. The people of the state of Nevada represented in Senate Assembly to enact as follows, Section 1 into Section 1.
Any further amendments?
There are none. Section 2 into Section 2, end of bill.
Senator Scheibel.
Thank you, Mr. President. SB 347 is primarily a mental health bill. It's intended to keep people and their families safe when somebody is experiencing a mental health crisis. SB 347 is also the common sense gun safety legislation. It is a bill that speaks directly to the situations where we can all agree that somebody should not be in possession of a firearm. And it meets all of the requirements of providing that person with adequate due process. What SB 347 does, as it was just amended, is it ensures that every police officer, the hardworking people who put their lives on the lines for us, are when they're out on the street, if they encounter somebody and they are charged with completing that process to bring somebody into custody on a mental health crisis hold, often known as an L2K, or a 48-hour hold, that officer is now, through the passage of SB 347, empowered with the knowledge that they absolutely have the ability to confiscate that person's firearm. If somebody is threatening violence against themselves or others, clearly as a result of a mental health crisis, an officer doesn't have to hesitate to remove the firearm from that person's pocket, their backpack, the table right in front of them, their immediate vicinity. It allows the officer to confiscate that firearm and to hold on to it for safekeeping. Because this bill is limited only to people who are being taken into custody or civilly committed under the law as it already exists for mental health crisis holds. What the law says about what happens after the gun, if we pass SB 347, is that the person automatically has it returned. They do not have to jump through any hoops. They do not have to file any petitions. All they have to do is go back to the agency that first confiscated the gun, appear in person, and retrieve their firearm back. The only exceptions to this are, one, if the person was previously a prohibited person and they were never supposed to have possession of that gun in the first place, or two, if that individual police officer who was faced with an individual in a mental health crisis in possession of a firearm and made the smart decision to remove that firearm from that person's possession, that officer has the opportunity to utilize an existing law that's outlined in NRS 33.360, a high-risk protection order, which I understand has been used less than 100 times total in the state of Nevada since its inception of a few sessions ago. So they can use this very specific, very narrow process to ask a court to issue an order preventing the return of the firearm, distinguishing between those people who really do only need a 48-hour hold, who are temporarily unfit to be in possession of a gun, from those people who do need a longer period to cool off, a longer time to be without their firearm. But it's not up to just anybody to make that decision. It's up to the police officer to file the petition and up to a court to grant or deny it. And but for those two very, very narrow exceptions, anybody who is released from their mental health hold after 48 hours or 72 hours or 2 weeks or 3 years, when they are released from that medical facility where they have been taken for their mental health crisis, they're able to get their firearm back. Because none of us want to see another tragedy occur here or anywhere else because a person who was in crisis was in possession of a firearm and made a bad mistake during a bad and difficult time of their life. So I really believe that this strikes the balance between protecting people's rights and protecting people's safety. I've worked very hard with law enforcement to ensure that I have the support from the sheriffs and chiefs. I have the support from the law enforcement agencies up north, down south, and in the rurals. And the police unions are on board. It's a collaborative effort to come to an agreement on this language, and I really strongly urge my colleagues' support.
Any remarks from the floor? Senator Hansen.
Thank you, Mr. President. Actually, I rise to first thank the Chair of Judiciary for the amendment. I think the main concern I had, and I think most of my colleagues did, was addressed, and that was they could take a firearm away from somebody without a judicial process, but to get it back required a judicial process. That has been removed by the amendment. The problem that we have, frankly, is the amendment came so late that all the people in the Second Amendment world, if you will, are convinced the bill is another example of a red flag law. So I'm going to have to vote no, but I think by the time it gets to the Assembly side that we can get the word out. I agree completely. This is a mental health issue, and the mental health crisis hold is completely reasonable, and I agree that somebody who's suicidal or homicidal should not have a firearm. So unfortunately, the timing of the amendment was a little rough. But again, I thank the chair for the chair of Judiciary for this. I'm going to have to vote no, but I believe by the time it gets to the Assembly, we'll probably be able to support this bill in the not too distant future. So again, thank you. I regret voting no, but at this point, because of the lateness of the amendment, the people that are supporting me expect a no vote on this, but we'll hopefully get that corrected in the not too distant future. Thank you, Mr. President.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 16 and noes are 5. SB 347 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 379, introduced by Senators Dignate, et cetera, revises provisions relating to commerce. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 35, end of Section 35, end of bill. This bill requires a two-thirds majority vote.
Senator Donate.
Thank you, Mr. President. Senate Bill 379 establishes various provisions relating to the distributed generation systems for electricity and certain entities that engage in advertising, providing loans, or installing such systems for customers. The bill prohibits a person from engaging in the business of a distributed generation system financer or manufactured home financer without being licensed by the Commissioner of the Division of Financial Institutions as an installment lender. Further, the bill imposes various requirements and prohibitions upon a distributed generation system financer who finances contracts or enters into agreement for the purposes of lease of a distributed generation system or power purchase agreement, and it makes other changes thereto.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 19, the noes are 2. SB 379 has received a two-thirds vote, is declared passed and ordered to the Assembly.
Senate Bill 404, introduced by Senate Committee on Judiciary, as amended, revises provisions relating to personal finance administration. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 32, end of Section 32, end of bill.
Senator Scheibel.
Thank you, Mr. President. This bill addresses some issues with administration of probate estates and ensures that individuals who are going to administer a probate estate are either the next of kin, an heir to the estate, an interested party, or they be required to go through the court process before making any major decisions like selling real estate out of the estate. It also makes a litany of other updates and revisions to our probate and trust section of the Nevada statutes. I know that the hour is late, so I'll just briefly kind of summarize the types of things it does include: increasing the amount for an estate to be set aside without an administration, establishes an alternative form to create an advanced healthcare directive, provides certain fiduciary duties, authorizes trustees to make distributions to a beneficiary without first creating a new trust in certain circumstances, and requires certain documentations to be provided to beneficiaries of trusts. And I urge my colleagues' support.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 404 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 408, introduced by the Senate Committee on Health and Human Services, revises provisions relating to county hospitals and county hospital districts. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, end of Section 5, end of bill.
Senator Donate.
Thank you, Mr. President. Senate Bill 408 authorizes the county hospital districts to employ and fix the compensation of dentists, county hospitals, and county hospital districts to employ medical and dental residents and fellows, but not interns, and the county and district hospitals to enter into a contract to provide with or form a separate organization to enter into contract or provide crisis stabilization services and certain other mental or behavioral health services.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 408 has received the constitutional majority, is declared passed and ordered to the Assembly. Senator Cannizzaro.
Thank you, Mr. President. I would move that the Senate stand in recess until the hour of 5:45 p.m.
We are in recess. The Senate is back in order. We are on order of business 8, waivers and exemptions.
Notice of exemption, April 22nd, 2025, the Fiscal Analysis Division, pursuant to Joint Standing Rule 14.6, has determined the eligibility for exemption of Senate Bill number 373, signed Wayne Thorley, Fiscal Analysis Division. End of notices.
Order of business 9, motions, resolutions, and notices. Senator Dondero Loop.
Thank you very much, Mr. President. I move to refer Senate Bill number 373 and re-refer it to Committee on Finance, as it appears it has a fiscal note.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I would move to take Senate Bill 449 from its place on general file and place it on the Secretary's desk for further discussion.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I would move to take Senate Bills 24, 41, 80, 179, 191, and 305 from the Secretary's desk and place them at the top of general file.
You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, nay. Motion carries.
That concludes order of business 9.
Order of business 13, general file.
Senate Bill 24, introduced by the Senate Committee on Health and Human Services, provides for the certification and regulation of emergency medical responders. People of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have none. Section 30 into Section 30 end of bill.
Senator Donate.
Thank you, Mr. President. This bill provides for the certification and regulation of emergency medical responders.
Any remarks from the floor? Seeing none, the Secretary will call the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 17, the noes are 4. SB 24 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 41, introduced by the Senate Committee on Revenue and Economic Development, revises provisions relating to the taxation of cannabis establishments. The people of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 14 into Section 14 end of bill.
Senator Neal.
Thank you, Mr. President. Senate Bill 41 requires that the cannabis tax permit be obtained from the Department of Taxation by any business wishing to engage in the sale of cannabis in Nevada.
Are there any remarks from the floor? Senator Orenshaw.
Thank you, Mr. President Pro Tem. I would like to disclose to the Chamber that my wife is a member of the Nevada Cannabis Compliance Board, and as Senate Bill 41 directly affects the Cannabis Compliance Board, I'm hereby making this disclosure for the purposes of Senate Standing Rule 23. I will abstain from voting on Senate Bill 41.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 15, the noes are 5, 1 not voting. SB 41 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 80, introduced by the Senate Committee on Growth and Infrastructure, revises certain provisions governing motor vehicles. People of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 8 into Section 8 end of bill. This bill requires a two-thirds majority vote.
Senator Hansen.
Thank you, Mr. President. Senate Bill 80 revises various provisions related to motor vehicles. The bill adds certain employees of the Department of Motor Vehicles to the list of people who may inspect, under certain circumstances, a vehicle's identification number, title, or registration for the purpose of locating a stolen vehicle. The bill also authorizes DMV employees who have the powers of a peace officer to obtain a court order to use a pen register or trap and trace device. Finally, SB 80 prohibits tampering with or removing emission control devices from vehicles. There is also a provision in Senate Bill 80 that removes an exemption for businesses that repair motor trucks over 10,000 pounds to comply with certain state laws. That last sentence is what requires a two-thirds vote. We have agreed to have that removed on the Assembly side, assuming it makes it out of the Senate. So I would urge its passage.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 19, the noes are 2. SB 80 has received the two-thirds vote, is declared passed and ordered to the Assembly.
Senate Bill 179, introduced by Senators Orenshaw, et cetera, revises provisions relating to discrimination. The people of the state of Nevada represented in Senate and Assembly to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. End of bill.
Senator Orenshaw.
Thank you, Mr. President. Senate Bill 179 requires the Nevada Equal Rights Commission, when investigating an alleged unlawful discriminatory practice in housing, employment, or public accommodations, to consider whether the practice was motivated by anti-Semitism. Additionally, Senate Bill 179 enacts the definition of anti-Semitism in the Nevada Revised Statutes for use by the Nevada Equal Rights Commission in these investigations. I urge its passage and support.
Any remarks from the floor? Senator Hansen.
Thank you, Mr. President. This is an exceptionally sensitive issue, but I have to stand up and be in opposition to the bill. We have an Equal Rights Commission about equal rights. Currently, the Equal Rights Commission can investigate practices of discrimination and acts of prejudice against any person or group because of race, color, creed, sex, age, disability, sexual orientation, national origin, and ancestry. All the stuff in this bill is already in state law. I'm very uncomfortable about this kind of a carve-out, and here is why. When you look at the definition of anti-Semitism, what is a Semitic race? The Syrians, Lebanese, Jordanians, Palestinians, Hebrews, the Iraqis, Syrians, the Saudis, the Egyptians, they're all a Semitic race. And when you define it this way, you basically exclude them from the protections of a law that's designed to prevent anti-Semitism. Now, in my mind, if in Reno, Nevada, there is an individual that is upset about what's going on in Gaza or in the West Bank, and they go and attack a Jewish individual because of that kind of a discriminatory practice, we would definitely define that as anti-Semitism. If the exact same scenario occurs and there was a Palestinian or an Islamic person who was attacked because of what Hamas has done in Gaza or the West Bank, in both cases, both of the individuals that would be assaulted would be Semitic people. And in my mind, if we're going to protect one group of Semitic people with a special carve-out in law, all Semitic people should be equally protected. If there was an attack in downtown Reno on a Buddhist temple or an Islamic mosque or a Christian church or a Jewish synagogue, in the eyes of the law, all of these types of crimes should be punished equally, investigated equally, and punished equally. So these kind of carve-outs I'm very uncomfortable with. Either we have equal rights, and either we follow the 14th Amendment, which clearly says no one will be denied the equal protection of the laws. And the last problem I got with the bill is the carve-out where you can have the Equal Rights Commission go after somebody based on rhetorical comments. Now, what does that mean? What is rhetoric? I went and looked it up. Here's what the definition of rhetoric is: the art of speaking or writing effectively, the study of writing or speaking as a means of communication or persuasion, and skill in the effective use of speech. In other words, we're asking the Equal Rights Commission to go and investigate people who speak things that we don't like. We've got a real problem with that. So while I certainly don't want anyone to ever be discriminated against on any basis, we should have equal application of the laws, and we already have it. All creeds are protected. All races are protected. All national origins are protected. All ancestries are protected. And I think all Semitic people should be protected from anti-Semitic behavior. Yet this law carves that out quite differently. So whatever race, religion, creed, color you are, all acts of discrimination should be equally punished and equally investigated. Now, I've watched in my lifetime. I remember when we had 9/11, 2001, there was a huge backlash against Islamic people in the United States. We even had a new term coined called Islamophobia. You don't hear that anymore. But there was absolutely a big spike against people who were Muslims in the United States. Then, after October 7th, 2023, very similar, big spike against people who were Islamic, but also who, for the most part, were Semitic races, Semitic people. And now we're having a backlash because of what's going on in Gaza and the West Bank and the decisions of the Israeli government, a backlash in some cases on college campuses against Jewish people. But in every single one of those cases, we already have laws in place that should promote investigations, prevent it as much as is reasonably possible, but all people should be treated equally in the eyes of the law. And these kind of carve-outs are unacceptable. Admittedly, it's just the Nevada Equal Rights Commission. But again, do we believe in equal rights or not? Do we believe in free speech or not? And if we do have certain carve-outs for Semitic peoples, shouldn't it be all Semitic peoples? So I'm voting no. I realize that this is very sensitive, but I think we should look very carefully at protecting all of our citizens equally in the eyes of the law. Thank you, Mr. President.
Senator Orenshaw.
Thank you very much, Mr. President. In response to some of the comments made by my friend from Sparks, Senate Bill 179 is not a carve-out. There's no carve-out that would have the Nevada Equal Rights Commission treat victims of anti-Semitism any differently than other victims of discriminatory practices. What Senate Bill 179 does do is provide a definition to guide the commission when there are investigations about public accommodation, housing, employment, discrimination. Certainly, there's nothing in this bill that would change how any allegations of discrimination based on those factors for any other group that you enumerated would be handled. So certainly, I don't believe there's any carve-out in this bill and adamantly oppose that. Have we seen a rise of anti-Semitism around the country and around the world? Of course we have, and it's horrifying and it's chilling. And this bill, while providing guidance to the Equal Rights Commission on how to identify that, to try to deal with those issues when that happens, that's what this bill does. It's not a carve-out that creates any differences between one group or another, but I think it's a very timely bill that is needed. I urge its support. Certainly I respect my colleague, but I think that that's a mischaracterization of the bill.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 20, the noes are 1. SB 179 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 191, introduced by Senator Daley, revises provisions relating to court reporters and court reporting firms. People of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 18, end of Section 18, end of bill. This bill requires a two-thirds majority vote.
Senator Daley.
Thank you, Mr. President. And I will first say that this bill was always going to be a work in progress. There's more work that needs to be done on the other side. With some of the timing, we couldn't get everything done on this side. I have agreed, and I will work with the Chamber, Resort Association, anybody else that has some issues trying to come to resolution, including the court reporters and the video recording sides of this issue. So with that, Senate Bill 191 changes the name of the Nevada Certified Court Reporters and Licensed Court Reporting Firms Law to the Court Reporting and Legal Recording Law Board. Requires the board to certify the individuals as certified legal recorders who provide legal recording to certain proceedings by the use of audio equipment, video cameras, or any system of recording simultaneous audio and video. Adopt regulations governing certified legal video recorders that include the establishment of a provisional, basic, and advanced certificate as legal recorder. Licensed legal recording firms, which are businesses that provide and arrange for certain services relating to certified legal recorders, replaces one board member who is a certified court reporter with a legal video recorder. The bill authorizes a person or business who on or before December 31, 2025 engages in legal recording of certain court-related proceedings or is providing certain referral services relating to such video recordings to continue such activities without certification or registration until July 1 of 2026 or another date as determined by the board. As I said, it's a work in progress. I'm telling you, we're going to work with everybody we have to on the other side and try to get this thing in order. Thank you.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 15, the noes are 6. SB 191 has received a 2/3 vote, is declared passed and ordered to the Assembly.
Senate Bill 305, introduced by Senators Danyate, Steinbeck, Crease Crawford, Flores, Wynn, and Orangeville, and Assembly members Torres, Fawcett, Hibbets, and Yeager, revises provisions relating to interscholastic activities. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments?
I have amendment number 549, proposed by Senator Taylor.
Senator Taylor.
Thank you, Mr. President. I move that we dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Taylor.
Thank you, Mr. President. I move that we adopt Amendment 549 to Senate Bill 305.
You've heard the motion. Senator Taylor.
Thank you, Mr. President. Amendment 549 to Senate Bill 305 simply makes it clear that it doesn't point out just one specific sport, but applies to all.
Are there any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 305 is ready for final consideration.
Senate Bill 305 by Senators Danyate, et cetera, revises provisions relating to interscholastic activities. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there further amendments?
There are none. Section 7 into Section 7, end of bill.
Senator Donate.
Thank you, Mr. President. Senate Bill 305 requires the Nevada Interscholastic Activities Association to adopt and post on its website regulations that provide for the process for the designation of a sanctioned sport, and the regulations must establish procedures for determining eligibility, prescribe competition rules, and other relevant items, and to prioritize the sanctioning process for currently established club sports at schools. The association must adopt such regulations no later than October 1st, 2025. Just want to take a personal privilege to thank, of course, the lacrosse community for coming forward in support of the bill, including the grandson of the senator from District 14. So I urge my colleagues to vote in support of the bill.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SB 305 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 202, introduced by Senators Ellison, Stone, and Steinbeck, revises provisions relating to real property. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3, end of bill.
Senator Flores.
Thank you, Mr. President. Senate Bill 202 makes it unlawful to intentionally procure or offer a false or forged rental agreement for the purpose of committing the crime of housebreaking or unlawful occupancy.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SB 202 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 208, introduced by Senators Steinbeck, Stone, and Danyate, revises provisions governing certain surcharges imposed by a county. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 8 into Section 8, end of bill.
Senator Steinbeck.
Thank you, Mr. President. Senate Bill 208 revises the authorized uses for revenue collected by a county from certain emergency reporting telephone surcharges. The bill also increases the monetary threshold that triggers reduced surcharges for associated special revenue funds in certain counties. This bill is effective on October 1st, 2025. What this bill does is it puts us in federal guidelines to be able to utilize these funds to update some of our dispatch systems where throughout the entire state are antiquated and need to be updated. What this bill also does not do in any way is affect the ability to utilize those funds for recording devices for law enforcement. I urge your support. Thank you.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 208 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 210, introduced by Senators Stone and Orangeshall, revises provisions relating to fees collected by constables and sheriffs for certain services. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 2 into Section 2, end of bill. This bill requires a 2/3 majority vote.
Senator Stone.
Thank you, Mr. President. Good evening, colleagues. Senate Bill 210 increases certain fees collected by constables and sheriffs for certain services, including, among others, taking a bond or undertaking or serving a summons, complaint, notice of eviction, writ of restitution, or subpoena. The effective date of the bill is October 1st, 2025. I appreciate your consideration.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 20, the noes are 1. SB 210 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 213, introduced by Senators Stone, Krasner, Steinbeck, Buck, and Ellison, revises provisions relating to the crime of unlawful dissemination of an intimate image. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 4 into Section 4, end of bill.
Senator Stone.
Thank you again, Mr. President and colleagues. Senate Bill 213 provides that a person who is 18 years of age or older that commits the crime of unlawful dissemination of an intimate image when, with the intent to harass, harm, or terrorize another person, the person knowingly distributes or causes to be distributed an intimate image if the image or representation is created in a way that would lead a reasonable person to believe it's an actual depiction of that person, and the person depicted did not give prior consent to the distribution of the image. The bill also expands the definition of intimate image to include certain photorealistic images, digital images, and computer-generated images. The effective date of this bill is October 1st, 2025, and I appreciate your consideration.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 213 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 215, introduced by Senators Titus and Daley and Assembly Members Watson and Urick, revises provisions relating to wildlife. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 3 into Section 3, end of bill.
Senator Titus.
Thank you, Mr. President. Senate Bill 215 requires the Board of Wildlife Commissioners to adopt regulations requiring Nevada's Department of Wildlife to issue salvage permits that authorize a person to salvage and collect any wildlife killed as a result of a vehicle collision or any other incidental event. The bill further prohibits the Commission from prescribing a fee for the issuance of a salvage permit. The Commission may, by regulation, prohibit the Department from issuing salvage permits if any wildlife in this state is confirmed to have tested positive for chronic wasting disease. Finally, the bill provides that a person holding such a salvage permit is exempt from prohibitions on having any wildlife or any part thereof during the time when the killing of such wildlife is prohibited. In other words, we have to apply for a tag in this state during hunting season. What this bill allows is if an animal is accidentally killed and somebody's going to harvest that and they're not during hunting season, they're prohibited from being fined. I appreciate your support. Thank you.
Any remarks from the floor? Seeing none, the secretary will open the roll. Oh, okay. Last time to change your vote. Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 215 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 235, introduced by Senator Hansen, revises provisions relating to wildlife. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 4, end of Section 4, end of bill.
Senator Hansen.
Thank you, Mr. President. Senate Bill 235 authorizes a person for non-commercial purposes to gather shed antlers or a skull or head with or without antlers or horns attached, or bones from the carcass of any wildlife species for which a tag is required under certain circumstances. The bill clarifies that the existing statutory requirement for the Board of Wildlife Commissioners to adopt regulations relating to the gathering of shed antlers only applies to gathering for commercial purposes. This bill just essentially allows you, if you're on a hike and you find a deer antler or a skull with horns and you want to take it home, you can without fear of breaking any laws. So thank you, and I urge its passage.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 235 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 276, introduced by Senators Hansen, et cetera, revises provisions relating to water. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 17, end of Section 17, end of bill.
Senator Hansen.
Thank you, Mr. President. This Senate bill is the one about Pyramid Lake. Senate Bill 276 requires any city, county, unincorporated town, general improvement district, wastewater district, or water authority of the state to notify Nevada's Division of Environmental Protection of any incident resulting in the discharge of sewage, industrial waste, or any other unauthorized discharge into the waters of the state under certain circumstances. Upon request by an Indian tribe, these same entities must provide the Indian tribe information that is a public record relating to any incident or water treatment policy. The bill further requires the Nevada Department of Environmental Protection, if notified of a discharge, to then notify any Indian tribe that may be affected by the discharge. The bill prohibits any city, county, unincorporated town, general improvement district, wastewater district, or water authority of the state from entering into a contract agreement or other legal mechanism that would prevent the sharing of such information with an Indian tribe. Finally, the bill applies certain provisions related to enforcement and civil and criminal penalties to violations of these reporting requirements. I want to reach out and a special thank you to Will Adler, who represented the Pyramid Lake tribe. Everybody's familiar. There was a 2 million gallon sewage spill, and nobody bothered to tell the tribe. Also, Nevada Conservation Natural Resources Director James Settlemeyer was very influential, and Jennifer Carr of the Nevada Department of Environmental Protection. So just want to know lots of folks worked on it. I appreciate the bill coming forward, and I urge its passage.
Any remarks from the floor? Seeing none, the secretary will open the roll. Senator Taylor. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 276 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 311, introduced by Senator Ellison, imposes certain requirements upon certain alarm companies. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 2, end of Section 2, end of bill.
Senator Ellison.
Thank you, Mr. President. Senate Bill 311 requires certain alarm companies that enter into a contract with the customers for alarm installation or monitoring, or after October 1, 2025, no later than 5 business days after receiving notice from the customers that the alarm system is defective or inoperable. Repair or replace the alarm system, 1. 2 is cancel the remaining of the contract, refund unearned monies paid by the customers without changing any penalties, fees, or costs because of the cancellation. Any violation of these provisions constitute a defective trade practice. This bill will become effective October 1. Mr. Chairman, I was kind of surprised to see how many out of Vegas and Washoe that the people come to us and said they're having the same problem we are in rural Nevada. So what they're doing is they're selling these alarm systems, but what they're not doing is when they go down is you can't get them out there to repair them. And we've had senators from this body had the same problem. So I asked my colleagues to please vote, and if there's any changes, we can do them over in the Assembly. But I think it's an important thing to do for protection for our families. Thank you.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Secretary will close the roll. Yeses are 21, the noes are 0. SB 311 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 336, introduced by Senator Rogish, establishes provisions relating to portable benefit accounts. People of the State of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, end of Section 5, end of bill.
Senator Rogich.
Thank you, Mr. President. Senate Bill 336 authorizes sole proprietors and independent contractors to open a portable benefit account with a credit union, bank, or investment manager and make account contributions during any calendar year they work as proprietors or contractors. Account distributions can be used for payments of various health-related costs or certain other benefit investments for the account holder or the account holder's spouse, domestic partner, child, or other dependent. A person who contracts for the services of a sole proprietor or an independent contractor may contribute to such a portable benefit account by certain means. The bill also provides that an account contribution is, in and of itself, insufficient to support any employee classification determination by the Labor Commissioner, who must make at least 3 additional findings of fact in support of any determination that a person was not properly classified. Thank you.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 19, the noes are 2. SB 336 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 371, introduced by Senators Steinbeck and Dignate, revises provisions relating to crimes. People of the State of Nevada, represented in Senate and Assembly, to enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, end of Section 5, end of bill.
Can we get a 1-minute recess?
Let's get the right one. 371, right? Okay. Okay. Senator Cannizzaro. Oh. Senator Steinbeck.
Thank you, Mr. President. Senate Bill 371 extends from 24 to 36 months the period during which a person who has been warned by an owner or occupant not to trespass is guilty of a misdemeanor for willfully going or remaining upon any land or in any building. This bill is effective on October 1st, 2025. I'd just like to state that Nevada's tourism and resorts are our main industry and the center of our economy. Events and resorts are what we do the best in the world. We have to make sure that our visitors and every bit or even more important, our employees always feel safe and secure in our resorts. SB 371 addresses a chronic problem with trespassing at our resorts. Expanding to 36 months allows law enforcement, security, and the courts to identify behavior of chronic offenders and to make more informed decisions as to appropriate charges and sentencing to end the repetitive cycles. I appreciate your support. Thank you.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 371 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 372, introduced by Senator Steinbeck, revises provisions relating to the care of children. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 4, end of Section 4, end of bill.
Senator Steinbeck.
Thank you, Mr. President. Senate Bill 372 adds to the list of circumstances in which a child is not considered to be abused or neglected, and the health or welfare of the child is not considered to be harmed, threatened, or injured, to include when a parent or guardian seeks to have the child admitted to a mental health facility or hospital if the child's behavioral health needs pose a risk to the safety and welfare of the family, and brings into the child's home a biological, foster, or adoptive child whose behavioral health needs pose a risk to the safety and welfare of the family. This bill certainly includes natural and adopted families. Certainly with adopted children, the ones that have unfortunate behavioral issues or problems related to drug abuse, those are the ones that need families see most. They're going to need that support for their entire lives. And parents take adoptive parents, they need more assistance than what we're giving them right now. Sometimes it just becomes overwhelming, and it certainly happens with natural-born children as well. But this was certainly brought to light because some of the struggles that some of the adopted families are having. And if there's anything on this bill is that it doesn't go as far as we would like it to. We all know we need more resources here, but this is as far as we can make it without some unintended consequences. So please support this bill. Thank you.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 372 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 382, introduced by Senator Hansen, revises provisions relating to the regulation of trailers. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 10, end of Section 10, end of bill.
Senator Hansen.
Thank you, Mr. President. Senate Bill 382 authorizes a 5-year registration option for trailers used primarily for farm purposes. At the time of registration, eligible registrants must pay the total amount of fees and taxes that would otherwise be due over 5 years if the trailer were registered annually. The bill provides that the expiration date of the trailer's registration is advanced by 5 years upon transfer of ownership. I want to have a special thank you to the Chair of Growth and Infrastructure. This bill originally had probably a record for a Republican, a $99 million fiscal note. So, needless to say, I didn't think the bill was going to survive. But the Chair, on her own, and without, I thought this is actually pushed by the Cattlemen's Association, but the Chair went and did this for me, and I'm very grateful. She got the bill, so the fiscal note is removed. And the whole idea is just to help people out who have trailers that they almost never use and give them an option of simply paying 5 years registration, and instead of being forced to every single year go through that process. So a special thank you to the Chair, and I do urge its passage. Thank you, Mr. President.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 382 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 410, introduced by the Senate Committee on Health and Human Services, revises provisions relating to public employees. The people of the state of Nevada, represented in the Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 2, end of Section 2, end of bill.
Senator Donate.
Thank you, Mr. President. Senate Bill 410 specifies that for collective bargaining purposes between a recognized employee organization and a local government employer, insurance benefits include without limitation insurance benefits for covered dependents of a local government employee.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 15, the noes are 6. SB 410 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 417, introduced by the Senate Committee on Growth and Infrastructure, revises provisions relating to natural gas utilities. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 15, end of Section 15, end of bill.
Senator Hansen.
Sorry, Mr. President. Senate Bill 417 establishes a regulatory framework that allows natural gas utilities to apply to the Public Utilities Commission of Nevada for approval of alternative rate-making plans. The bill requires the PUC to adopt regulations outlining the procedures, required content, evaluation criteria, and permissible mechanisms for such plans. Utilities may propose these plans either during or within 6 months of a general rate case. Alternative rate-making plans must include a consumer education component, and the PUCN must hold at least one public input session before a plan's approval. The bill authorizes the PUCN to investigate and adjust any rates or practices under an approved plan and sets conditions under which utilities may recover capital expenditures outside of general rate cases. Additionally, the bill provides that if the PUC approves a utility's application with modifications, the utility has 30 days to accept or reject the modified plan. Finally, SB 417 clarifies that the bill's provisions do not limit PUCN's existing rate-making authority, and it becomes effective October 1st, 2025.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 21, the noes are 0. SB 417 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Bill 426, introduced by the Senate Committee on Natural Resources, establishes provisions relating to the Lake Tahoe Basin Scenic Byway Corridor Recreation Safety Zone. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. End of bill. This bill requires a 2/3 majority vote.
Senator Daly.
Thank you, Mr. President. Senate Bill 426 creates the Lake Tahoe Basin Scenic Byway Corridor Recreation Safety Zone, consisting of any portion of U.S. Highway 50, Nevada State Route 28, Nevada State Route 431, and Nevada State Route 307 within the Lake Tahoe Basin, Lake Tahoe region, and is entirely directly connected to recreational area or has been designated as a scenic byway. Further, it establishes parameters relating to parking in the safety zone, including but not limited to enforcement and the collection of fines.
Any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. Yeses are 21, the noes are 0. SB 426 has received a 2/3 vote, is declared passed, and ordered to the Assembly.
Senate Bill 428, introduced by the Senate Committee on Legislative Operations and Elections, revises provisions relating to public office. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows: Section 1, end of Section 1.
Are there any amendments?
There are none. Section 13, end of Section 13, end of bill.
Senator Orenshaw.
Thank you very much, Mr. President. Senate Bill 428 revises provisions concerning the eligibility of public officers to remain in office in the case that they no longer reside in the area prescribed by law. The measure adds this obligation to Nevada's public policy declaration concerning residency. All members of the legislature and public officers under SB 428 will be required to swear additional oaths, including stating that they will relinquish office due to a vacancy prescribed by law. The oath of office provisions of the bill do not apply to current office holders. Notice of any change of address must be to the entity that accepted the candidate's filing for office. Except for certain confidential information, a candidate's proof of identity and residency will be a public record. In addition, the certified candidate list exchanged between state and local election officials must contain the candidate's actual residence. Electors with knowledge or evidence of certain events may file a challenge to an incumbent on the grounds that a vacancy in the office has occurred as a result of such events. Additionally, an elector who files a challenge on the grounds that the person fails to meet a qualification for office is required to be notified of the time and place of the challenge hearing. If vacancies for a nominee to a partisan office occur prior to certain July deadline, the nominee's political party may select a replacement candidate. For legislative districts occupying more than one county, the county commissioners may jointly select a candidate for vacancies occurring after the July deadline. The nominee's name remains on the ballot and a vacancy exists if the person is elected. For vacancies in a city general election occurring after the July deadline, for such elections, the nominee's name will likewise remain on the ballot, and if elected, a vacancy exists. Senate Bill 428 will ensure that public officials who are elected in one area they're supposed to represent continue to reside in that area. If they move out of the area, they should no longer hold that office. I urge its passage. I urge its support.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 14 and noes are 7. SB 428 has received the constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 437, introduced by the Senate Committee on Commerce and Labor, enacts provisions relating to Internet consumer lenders. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 5 into Section 5, end of bill.
Senator Pizzina.
Thank you, Mr. President. Senate Bill 437 authorizes an internet consumer lender to apply for a license to engage in the business of lending for an office or place of business located outside of Nevada without having a physical location inside this state, and establishes certain exemptions for such a licensee. This bill requires any contract between an internet consumer lender and a Nevada resident for the provision of a loan must provide the contract is governed by Nevada laws and requires certain processes for the resolution of disputes arising out of the contract occur in the state. Any contract condition, stipulation, or provision that conflicts with these requirements is contrary to public policy and void and unenforceable.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 20, the noes are 1. SB 437 has received the constitutional majorities, declared passed and ordered to the Assembly.
Senate Bill 440, introduced by the Senate Committee on Commerce and Labor, revises provisions relating to electricity. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 30 into Section 30, end of bill.
Senator Lang.
Thank you, Mr. President. Senate Bill 440 revises various processes and requirements relating to agreements of solar installation companies and distributed generation and net metering systems for electricity. It establishes procedures by which a unit's owner in certain unit owners associations may submit a request to install a distributed generation system, as well as certain powers and duties such as unit owners association with respect to such installations. The procedure and contents of making such a request are specified as the provisions concerning the process of appealing the denial of request. This bill is effective upon passage and approval for the purposes of adopting regulations and performing preparatory administrative tasks, and on October 1, 2025 for all other purposes.
Are there remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21, the noes are 0. SB 440 has received the constitutional majorities, declared passed, and ordered to the Assembly.
Senate Bill 443, introduced by the Senate Committee on Growth and Infrastructure, revises provisions relating to public works. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
I have amendment number 550, proposed by Senator Cannizzaro.
Senator Cannizzaro.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Cannizzaro.
Thank you, Mr. President. I move to adopt amendment number 550 to Senate Bill 443.
You've heard the motion. Senator Cannizzaro.
Thank you, Mr. President. Amendment number 550 to Senate Bill 443 makes several clarifications, including that the provisions of the bill do not apply to contracts awarded by a public utility by a contractor that includes also a work site agreement.
Any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 443 is now ready for final consideration.
Senate Bill 443, introduced by the Senate Committee on Growth and Infrastructure, revises provisions relating to public works. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any further amendments?
There are none. Section 4 into Section 4, end of bill.
Senator Cannizzaro.
Thank you, Mr. President. I rise in strong support of Senate Bill number 443. Senate Bill number 443 requires that prevailing wages be paid on large construction projects where they have a significant investment for operational or capital improvements by utilities here in this state. It makes exceptions for things like a collective bargaining agreement, a project labor agreement, or for worksite agreements that already exist between those utilities and the contractors who are doing those types of work. But I think the importance and what cannot be overstated enough in this particular bill is that when we are talking about how it is that we are supporting the working families in Nevada, we are talking about whether or not somebody is going to work, making a wage for a hard day's work, making sure that when they have the training and the safety precautions and all the pieces that come along with making sure that you can work on these sorts of projects, that we owe it to them to be able to pay them the kind of wage that allows them to support a family, that allows them to access health benefits, that allows them to talk about retirement. I think that's the very least that we can do for working families here in Nevada. And so this is sort of a small step in that regard. And I know that there has been some concern over why we would establish prevailing wages on public utility projects. I think there are a couple of things to note. Utilities here in this state occupy a very different space than ordinary businesses. Oftentimes, they occupy that monopoly space. And so there is not regular competition. This is not a normal market. And I think when we talk about how it is that those particular utilities are sustained, we're talking about people's dollars that are going into those public utilities. And so on balance, why prevailing wage is important for these sorts of projects is to make sure that we're supporting working Nevadans who are trying to raise their family and do what's right, and that we are putting public trust into those procedures to make sure that we can actually compete and have Nevadans working on these jobs and making those fair wages. So I stand in very strong support of Senate Bill 443. I think it supports working families here in Nevada, and I would strongly urge my colleagues' support.
Any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 13 and noes are 8. SB 443 has received the constitutional majority, is declared passed, and ordered to the Assembly.
That concludes order of business 13.
Order of business 9, motions, resolutions, and notices.
Senate Joint Resolution 1, introduced by Senator Krasner, urges Congress to enact legislation allowing certain eligible surviving spouses of veterans to receive an amount equal to the military retirement pay of the veteran after the veteran's death. End of resolution.
Are there any amendments?
There are none.
Senator Krasner.
Thank you, Mr. President. Senate Joint Resolution 1 urges the United States Congress to enact legislation for veterans to allow an eligible spouse who opted to receive the surviving veteran's spouse benefit through the Survivor Benefit Plan to receive an amount equal to the veteran's military retirement pay after the veteran's death. Thank you.
Any remarks from the floor? Seeing none.
Point of
Senator
order,
Cannizzaro.
Point of order, Mr. President. I don't think we actually have a motion on the floor. I think we do not have a motion. We heard some remarks, but no motion.
Okay. The joint resolution will be a roll call vote, but does not need a motion. So, any further remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 21 and noes are 0. SJR 1 has received the constitutional majority, is declared passed, and ordered to the Assembly.
Senate Joint Resolution 9, introduced by Senators Titus and Hansen, urges the Citizen Stamp Advisory Committee and Postmaster General of the United States Postal Service for the creation of a postage stamp commemorating John Snowshoe Thompson. End of resolution.
Any amendments?
There are none.
Senator Titus.
Thank you, Mr. President. I think John Snowshoe Thompson would be very honored that he is the last person acknowledged on a rather long day. So I appreciate the opportunity. Senate Joint Resolution 9 urges the Citizen Stamp Advisory Committee and the Postmaster General of the United States Postal Service to create a postage stamp recognizing and commemorating the contributions of John Snowshoe Thompson. The resolution describes his efforts over 2 decades to deliver mail between Eastern California and Western Nevada, traveling through the snow-covered Sierra Mountains on ski-shaped snowshoes. Among his other achievements, Senate Joint Resolution 9 describes his heroic deeds assisting travelers during the harsh mountain winters. The resolution also notes the 200th anniversary of his birth will occur in April of 2027 and encourages the issuance of the stamp to observe the event. And if any of you would like to see what those snowshoes, AKA skis, look like, they are in my office. I have a pair and I've skied with them, so I won't necessarily demonstrate what that looks like when me on those skis now, but they certainly are beautiful. And he never got paid for his services, and the very least they can do after 20 years of service is to give him a stamp. So I appreciate your support of this. Thank you very much.
Any further remarks from the floor? Seeing none, the secretary will open the roll. Okay, nobody else is changing their vote. Secretary will close the roll. Yeses are 21, the noes are 0. SJR 9 has received the constitutional majority, is declared passed, and ordered to the Assembly.
That concludes order of business 9.
Taking a 1-minute recess.
All right, we are in recess. The Senate is back in order.
That concludes Order of Business 9.
Order of Business 16, remarks from the floor, introduction of guests. Senator Cruz Crawford.
Thank you, Mr. President. In true principal fashion, I'm going to keep us after class today to celebrate Earth Day. As the chair of Natural Resources and an educator, I want to make sure you leave every day learning something new. So today, on Earth Day, I want to let you know it was established in 1970, largely due to the legislative efforts of Senator Nelson in Wisconsin. And Senator Hansen, you're going to like this. It was following a significant environmental damage caused by major oil spills. Senator Nelson's commitment to environmental protections is a testament to the impact of our dedication and leadership, and it should serve as an enduring source of inspiration to undertake this difficult work. On a personal note, as a chair of Natural Resources, I've had the privilege this session to learn so much about our state's land, water, air, and efforts from my colleagues and a lot of our lobbying groups that have educated me. Our conservation efforts tell not only part of the story, but Nevada's public lands are a resource that are driving a lot in our economy. Did you know that renewable energy production plays an even bigger role, contributing to over $15 billion and sustaining 21,000 jobs every year in Nevada? So while today is deadline day, and I was supposed to say this during the first agenda, so it's a little outdated. So while today is deadline day and we spend most of our day on the floor today, I hope everyone takes a few minutes to get outside while the sun is shining and is able to go. Okay, last item. I would be remiss. I know that Senator Titus was really excited that the last person we were going to acknowledge today was Snowshoe Thompson. Unfortunately, that's not the case. I want to acknowledge my intern, Brandon Michelle. Today is his birthday, and Brandon is a lifelong Nevadan raised in Northern Nevada. He's a proud graduate of Spanish Springs High School. He drives here twice a week, an hour and a half to intern through UNR. He is a graduate of the JROTC program and the Job for America program. He's demonstrated a clear commitment to civic engagement, and he ran his political science club at TMCC. He walked through neighborhoods canvassing and met local leaders, and he's been dedicated to voting ever since he was 18, so about 4 years. And while he's not in the legislative building every day, I appreciate all the knowledge that he brings to me as a young citizen in Nevada. It's an honor to have Brandon on our team this session, and I just want to say happy birthday, Brandon. Thank you, Mr. President.
Senator Flores.
I also rise in support of Earth Day. Thank you, Mr. President.
Mr. President, I rise in support of
I didn't
oil spills.
I didn't call on you, sorry.
Sorry.
All right, before things get any further downhill, anything else? All right, Senator Cannizzaro.
Thank you, Mr. President. Unlike my principal friend from Senate District 1, who kept us here way too late, tomorrow, since we have done a lot of business here on the floor, I'm going to be like the cool teacher in school and let y'all sleep in a little bit. We are going to come back here. You may remember, members, we have an address from Congresswoman Dina Titus to receive in the Assembly in joint session tomorrow evening. So we will convene here at 4:30 to do a bit of business before convening with the Assembly. So, Mr. President, with that, and in support of Earth Day, obviously, I would move that the Senate adjourn until the hour of 4:30 p.m. on Wednesday, April 23rd, 2025.
Thank you. You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are adjourned.